38-page criminal complaint. Those conversations do not implicate Robert English. Court can't find anything that indicates a conspiracy. I cannot find probable cause.
I'm not going to amend the complaint. We need to do the prelim.
We're not going to have a preliminary exam on misdemeanors.
We would not. So if you want it, I can dismiss all counts.
This fellow here, Robert English, was apparently caught with some loot heisted during a burglary. The state says he conspired to commit that burglary with 2 co-defendants, except they don't have any evidence that he knows the others or knew they were going to do it. The state, represented by Kevin Schmidt, just doesn't seem to get it. He's going a few rounds with Judge Mogen to let her know that besides holding a flawed 38-page criminal complaint, he's also holding on to some sour grapes. Let's roll, nerds.
We will go on the record in the matter 25 CF44, State of Wisconsin versus Robert English. The state appears through District Attorney Kevin Schmidt in person. Mr. English appears in person in custody with counsel Eugene Harrington. We're set here today in this matter for a motion hearing, a 4 corners motion hearing, in which the court received 2 briefs from both sides, well, a brief from both sides, and also has thoroughly reviewed multiple times the criminal complaint, which is a 38-page criminal complaint in this matter. However, with regards to that, there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 charges in that criminal complaint that does contain 38 or 36 counts, criminal counts, but 12 of those counts relate to defendant Robert English. We are here today for the court to hear any arguments to supplement the briefs, because again, this is I want to say a complex, or it has a lot of facts and things alleged in the criminal complaint as well as in the arguments. So I am going to start with Mr. Harrington. This is your motion. Again, I have thoroughly read your brief along with the criminal complaint. As it relates to this case and any argument, what would you like to state?
Judge, nothing. I'll rely on my brief to accept anything that I quoted in the brief, cited in the brief, was based upon either a review of the cases that I cited or the jury instructions. I'll stand on the brief. Thank you, Judge.
All right, thank you. Mr. Schmidt?
There's a reason why the test for adequacy of a criminal complaint is described as common sense and not hyper-technical. If the complaint was only 1 sentence long and the 1 sentence was 4 people who reside in Burnett County reported their house was broken into, damage was caused with the breaking in, and stuff was stolen, and the stolen property from all 4 were found in Robert English's bedroom, that would be an adequate complaint. This complaint actually contains that information as well as a plethora of other information. The court has already found probable cause for all 12 accounts when it issued the arrest warrant. Attorney Harrington has not pointed out anything I think the court missed. Thank you.
All right, Mr. Harrington, any reply?
No, I'll stand on the brief.
All right. Again, the court has reviewed both of the briefs that have been submitted by the parties in this case. First, the court must address the issue of the arrest warrant and the argument that the court has heard that the court found probable cause when it issued the warrant. This is not entirely accurate. The court did find probable cause that a crime was likely committed or probably committed, but not that a felony was probably committed or which of the crimes could have probably been committed. And there's a difference. A preliminary hearing would determine whether or not there is enough facts or evidence alleged, even with inferences to the state, to determine whether a felony was probably committed. Whether or not the burden has been met with an arrest warrant of a crime being probably committed, it's determined about the facts alleged, and the court did determine that a crime was probably committed and issued the arrest warrant. Second, the court has thoroughly and carefully reviewed the criminal complaint multiple times while examining both of the submitted briefs. The court has reviewed the voluminous communications within that criminal complaint, which would be text messages between the co-defendants. Those written communications among the parties discuss potential burglaries, which then would give the inference or the connection to the criminal damage to the property and perhaps possession of stolen property or misdemeanor theft, moving of property. However, those conversations specifically in reviewing each of those texts very specifically, those conversations do not implicate Robert English in any of the burglaries, which would then connect to the criminal damage to the properties, only that they may relate to the probable possession of stolen property or movable theft or theft of movable property. So in the court's review, I cannot find the evidence or the facts presented in the criminal complaint to connect Mr. English and the commission of the burglaries and the connection to the criminal damage to property. Could Mr. English could he have possibly known about the burglaries? Yes. Could he have possibly helped in committing those burglaries? Yes. But in the review and as the facts and statements and the specific details are laid out in that criminal complaint, reviewing the criminal complaint and what's laid out in detail in that criminal complaint, it would only be speculation or conjecture because of the close connection Mr. English has to the co-defendants. One of the co-defendants is his girlfriend of a significant long period of time, and the other co-defendant is her brother. But there is that close connection in those written communications as to the likely stolen property and it being in possession of or going to be or something to be done with, probably with Mr. English. There's a connection to that. Even as stated in the criminal complaint, in reviewing and looking for the conspiracy requires a mutual understanding to achieve a shared criminal goal and to work together to carry out that criminal plan. There must be some type of either words or actions or intent by the defendant to complete that crime. In the criminal complaint, as again, it is laid out and described in specific detail, the court can't find anything that indicates a conspiracy without having mere speculation or conjecture. This is insufficient for the court to link the defendant to the crime of burglary or to the relation with the crime of criminal damage to property. Although the state does correctly state that conspiracy does not require the co-conspirators to have an explicit or formal agreement, meeting, or even know each other, there still must be more than speculation or strong opinion or belief to link the parties to committing a crime like burglary or criminal damage to property. The details and the specifics as related to the burglary and then the criminal damage to property, as outlined in that criminal complaint in the court's review, does not provide sufficient inference to connect Robert English to those acts. This is in contrast to the court's review with the allegations of the possession of stolen property, theft of movable property, those and the conspiracy to commit the misdemeanor theft as a party to a crime with that movable property. The court determines that that criminal complaint contains enough facts and specific details to reasonably believe and probably believe that Mr. English did commit or co-conspired to commit those crimes, allowing those charges to move forward. But with regards to the burglary and the criminal damage to the property, the court cannot find enough to connect, even with an inference, without mere speculation or conjecture, to connect Mr. English to those crimes. So I'm believing you understand that the court is saying with regards to the charges, the court can only find enough to connect as it relates to the conspiracy to commit misdemeanor theft as a party to a crime with the movable property. So I believe that is only counts 6, 15, 24, and 33. Mr. Harrington, you look like you want to say something.
I haven't thought through what I want to say because I think those are all misdemeanors at this point, aren't they?
They are.
I guess as I recall the rules, Mr. Schmidt has the opportunity to amend the complaint.
He does.
Rather than a dismissal. And I guess I want to know how long it's going to take him to amend the complaint and where we go from there. And suggest that maybe the court set this for a status.
I'm not going to amend the complaint. We need to do the prelim. We need to get this case moving. One of his co-defendants has invoked speedy trial.
Fair enough. We'll set it for preliminary exam. I have time. If the court is finding that everything except 6, 15, 24, and 33, the complaint lacks that. The motion is an attack on the personal jurisdiction. I think there has to be an amended complaint. These are misdemeanors. We're not going to have a preliminary exam on misdemeanors.
We would not.
I thought the court dismissed the crim damages.
And the burglary.
So the court found probable cause to believe that Robert English was knowingly in possession of stolen property from the theft, which is an essential part of the conspiracy, but would not find the burglary and crim damage that were necessary for the theft, even though the conspiracy jury instruction says he doesn't need to know about those or be part of it.
I think
That's
that's
my
precisely what the judge found, and I agree with that.
Exactly what I found in the review of the criminal complaint. And again, you do have the ability to amend the criminal complaint. I could find, and again, in reviewing the jury instructions for conspiracy, it requires at least a mutual understanding and a shared criminal goal to work together to carry out a criminal plan. He would need to know that the burglary was going to be in existence. And I can't find that there is any connection.
It does not require that you all have the mutual understanding of the same crime, just a criminal purpose. That's why the jury instruction reads that.
Again, I can't find in the facts, especially in looking at the text messages and the communications between the co-defendants, that Mr. English was involved in the criminal purpose of the burglaries. Did he possess the stolen property? Probably with the facts.
That's what I'm getting at with the conspiracy in this. It's really all or nothing. If the court believes that he was part of the theft, as in he knew the property was stolen and possessed it, he's also party to a crime conspiracy on those others. It has to be all or the other when it's all part of one scheme.
But not necessarily. There could be a scheme. I don't see a scheme here. I see any individual could receive stolen property from their friend Joe. Joe could say, hey, dude, I stole this. I got this. Let's sell this. Doesn't mean that the guy was a part of the decision to steal the property.
Then the court couldn't bind over on the theft because that has a knowing element too. That's the problem.
Well, I find that there's probable cause to believe that he was in possession of stolen property and knew that it was stolen.
So is the court actually dismissing all counts then? Because we didn't charge receiving stolen property.
Again, you can amend if you wish. I'm saying there's enough probable cause to believe a crime was probably committed. What that crime is and how it's laid out is for the state to prove. I'm seeing that there is at least enough to determine probably he was involved in the conspiracy to commit the misdemeanor. Well, to have the stolen property. He had stolen property. So if you want to, I can dismiss all counts.
I am
But the
not
state-
amending and receiving stolen property. If the court is not finding probable cause for all three counts, that's what I'm checking.
Mr. Harrington, if he does not want to proceed with the other misdemeanors that are
I
stated.
didn't charge receiving stolen property as a thing. The court's saying it's only finding probable cause for something I didn't charge is what I'm hearing.
I think the judge addressed me. I'm to answer the question. that
Yes,
the court
Mr.
posed.
Harrington.
As I mentioned, the rules require or give the state the opportunity to amend where a court finds that there's not facts sufficient in the criminal complaint to impose the jurisdiction of the court over this particular defendant. The state has that right by statute. What Mr. Schmidt is arguing, the court decided that there aren't facts sufficient to connect those inferences that they want to have connected for the felonies. If, as I understand the court's decision, the court found that there is no basis for the conspiracy as it relates to the burglary and the criminal damage to property, but that there is for count 6, 15, 24, 33, those are misdemeanors. If Mr. Schmidt wants to amend, fine. But I don't view that we need preliminary exam for those particular crimes. They're misdemeanors, even if it's
We do
misdemeanor.
not. And that's the court's view is I find probable cause that a crime, a misdemeanor crime was probably committed by Mr. English. There is definitely enough there to connect that. And you agree, Mr. Harrington, Yes, you're nodding your head up and down.
Yes.
Yes, you agree. And even in your brief, you agree that there is enough to say Mr. English probably committed.
There's probable cause to believe.
Correct. There's
Except
probable
for-
cause to believe
yeah.
that he did commit misdemeanors. Whether or not the state wants to continue and to pursue the misdemeanors as charged, that's a determination for the state.
Correct.
The court is not dismissing those misdemeanors. As stated on the record by Mr. Harrington, and I have them written down somewhere as to what they are. But I don't have them, I don't know where I wrote them down on which. 15, 18, no,
6, 15, 24, 33, Judge. Those are the ones you recited out of the record.
correct. Those misdemeanors stand in the court's review of determining probable cause that a crime was probably committed by Mr. English. The other allegations, the court cannot find any connection as laid out in the criminal complaint. But again, the state has the ability to find other information or to put other things in that criminal complaint that would tie it to a conspiracy for criminal damage or conspiracy for burglary. I just can't find it. And I'm going to tell you, I reviewed that 38-page criminal complaint at least 3 times, perhaps more.
Here's the issue of confusion I'm having. I'm hearing the court saying it's finding probable cause for the counts that are misdemeanor theft, movable property, where the state's alleging that Robert English took property out of the home.
No,
during the
that is not what that is not what the court is saying. The court is saying, just like any preliminary hearing, when I have
This is not a
Mr. Schmidt, it's not, but this is my example to show you. In a preliminary hearing, the court has to find probable cause to believe a felony, not the felonies that are charged by the state, because sometimes the state charges them wrong, or sometimes the state doesn't add additional felonies that they could find. In court's review of a complaint as it relates to misdemeanors, and Mr. Harrington can tell me if I'm wrong, in review of a misdemeanor criminal complaint with misdemeanor charges, the court has to determine if a misdemeanor crime was probably committed by the defendant, whether or not the state has accurately and correctly charged the crime that should be charged. Am I not correct, Mr. Harrington?
You're absolutely correct, Judge.
Absolutely correct.
I don't believe that's correct. I think when it's a four corners motion, you challenge the actual counts in the complaint, meaning the court's not deciding whether or not a misdemeanor occurred when it reviews the complaint. It's deciding whether there's probable cause for each of the counts in the complaint.
Mr. Harrington,
That is how 96801.
if you want me to dismiss all of the counts, I surely can, but I'm finding that there is probable cause to believe Mr. Robert English has committed a crime, and in review of the criminal complaint, as it is stated with every single word in there, probable cause to believe he committed misdemeanor crimes.
And my understanding is what I'm trying to articulate is what I'm hearing from the court is the probable cause for the misdemeanor the court is hearing is not the misdemeanor theft we charge. It's receiving stolen.
I can't even say that. Even in a preliminary hearing, I can't say I find probable cause that a burglary was committed, because the law says I have to determine probable cause of a felony or probable cause of a misdemeanor. If you believe and you want to have the court dismiss all of the counts as it relates to Mr. English, because the court found probable cause for a crime, but you're believing that with the four corners, that means the court has to dismiss all because the court's looking at, did he commit that crime? You're putting the court in the spot of being a jury for the court to determine if the facts of the case relate to whether or not Mr. English committed misdemeanor theft, moving stolen property. I am not the jury. Right now, I am just here to determine probable cause to commit a crime. I find probable cause Mr. English committed misdemeanor crimes, at the very least, as it's alleged in the criminal complaint. What the state wants to do with it, the state can do with it. But as to those other counts not stated on the record, I cannot find probable cause. So as of this court's review, all counts except 6, 15, 24, and 33 are dismissed. Whether the state wants to pursue the theft of movable property or to amend to something else, or to amend the whole criminal complaint to find other connections with Mr. English and the burglary and the criminal damage to property charges, the court or the state can. But that's what I'm finding. And again, I think my review and my understanding of case law, my understanding of the statutory law, I believe I'm correct. And again, I'll hear Mr. Harrington. What do you think?
I agree with you, Judge.
The problem I'm running into is if the court is just finding if that probable cause of a misdemeanor exists, I don't know why the court dismissed the crim damage and kept the theft, why it did make a decision to choose one and not the other.
Criminal damage is so connected to a burglary because you're alleging that he had the conspiracy to commit that criminal damage of breaking a door or breaking a window or breaking those other things to damage that property. If the court cannot find a connection other than speculation or conjecture that Mr. English, with the facts again, as stated in the criminal complaint, conspired to commit a burglary of a building, the court cannot find that he conspired to commit criminal damage to property. Again, as to the other property, the property that is of issue here, the court can find probable cause he committed a crime. Again, if you want the court to dismiss all of the counts, I surely will.
I want the court to find there's probable cause for all. I'm being careful with my language because I'm trying to figure out if this is a final order finding no probable cause for any of the counts, or if it's, and that the court thinks there is probable cause for some misdemeanor not in the complaint, or if the court's finding that, because the state did not allege receiving stolen property. The state
Correct.
alleged that
Exactly. I'm going to
state-
tell you, okay, I find probable cause that a crime was committed. I find based upon the charges that are charged right there, removing the ones the court cannot connect to Mr. English, that there's probable cause to believe a crime was probably committed and it relates to the charges that are filed. Again, whether or not the state charged the correct charge, the correct criminal charge, or what the state can prove to a jury is for the state to determine. But I'm not dismissing counts 6, 15, 24, or 33 unless the state asks me to dismiss them all. Then I will. I have no problem doing that.
I do not. I believe there's probable cause for misdemeanor theft. Thank you.
All right. Thank you. Then those counts stand. Anything further?
I have to chat with Mr. English about some things. I'm not sure what this does with the trial on with these other two defendants, frankly.
Well, that's for you to talk to the state and that's for that to be figured out. And here's the thing. I understand that you represent Mr. English. The court needs to have the speedy trial. We're having the speedy trial when it's set. If you can't be here, Mr. Harrington, Mr. English, and he needs to be a part of that trial, Mr. English will then need to get a different public defender.
Thank you, Judge.
We will go on the record in the matter 17 CF 194 and 17 CM 320, State of Wisconsin versus Michael Frank. Michael Frank appears by video conferencing in custody in Burnett County Jail. Mr. Frank, before we begin, when were you picked up and arrested on this warrant?
Tuesday of last week.
Tuesday of last week. So let me just see when that was. So that would be approximately September 9th. Is that what you're telling me?
Yeah, it was either the 9th or the 8th that I got picked up.
The 8th or the 9th. Okay.
Yeah.
And today is the 16th. All right, Mr. Frank, can you please raise your right hand?
Yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Frank. I'm sure you recall me and you remember me. I remember you very well from your 2017 case, and I believe that I had some failure to pay warrants throughout the years, maybe a couple times. I can't recall exactly off the top of my head. I do know that at one time you were living with your father in either Lewis or Frederick or something in that area of Polk County.
Yes.
Are you living with your father right now?
My father died last year. So right now we're in the process of selling the house. And like right now, I don't have any funds to even bail out. I don't have any funds to make phone calls or do nothing. So like right now I'm waiting to see if I can get like a SIG bond out with this stipulation. We're supposed to sell the house within a week or two. But I
All right.
can't do that being in custody because I can't sign the paperwork. I have to be there present.
I totally understand that, Mr. Frank. And Mr. Frank, I do recall, I can't recall exactly specifically since it's been 8 years, but that you either suffer from some mental health or disorders
Yeah.
or issues like that, and that you were trying to get a job, but it's very difficult for you to keep a job. Is that all correct?
Yes.
So what have you been doing since 2017? How have you been supporting yourself?
Well, with my dad passing last year, I've more or less tried living out there. I've tried to live with Jim Studi out on 48 outside of Luck. That didn't go over well because right now he stole all my stuff from my dad's house, so without permission. So right now
So
it's
technically you're homeless except for the house that you're going to be selling?
yeah. Like right now, I have been staying for the last 2 weeks prior to me getting arrested. I was staying out on County Road F outside of Grantsburg, down the road
Okay.
from the country store.
Now, are you able to work? Do you get Social Security? Do you disability
No.
or anything?
I don't get any of that. I don't even collect food stamps because I'm not allowed to.
So you have zero income right now.
Zero income.
All right. And when was the last time you've been employed?
Say beginning of the year when I worked at Applied Molding.
Okay. And how long was that job?
I worked there 2 weeks and then got fired because I got a tooth infection.
Okay. Are you addressing your mental health and mental disorders?
Yes and no.
What does that mean?
Like, yes, I am, but at the same time, the medication they want me to take, I don't want to take it because it makes me sleep 24/7.
Have you been back to the doctor and revisited your medication and perhaps there's a different one that you could take that won't do that?
Not yet. I was in the process because right now I have to reapply for insurance.
Okay. And are you going to do that?
Yes. As soon as I get
promise?
out. I
You
promise.
promise me?
I'll do it as soon as I'll do it today if you let me out today.
And do you promise me that you're going to go back to the doctor and you're going to revisit and look at the medications and perhaps there's one that you can take that won't make you sleepy all day?
Yeah.
And have you been convicted of any crimes in the last 5 years?
Yeah.
Like
I got 3 years ago I got convicted of possession of methamphetamine.
Okay. How are you doing with that substance abuse?
I've been clean for 9 months now. So
Okay. And what are you
But,
doing to stay clean?
but at the same time, I took 2 charges in July for a friend because he was on probation in Polk County. So
This past July?
yes,
For what?
possession of methamphetamine and possession of THC, but it should only been drug paraphernalia. But since I have 5 convictions of it or 4 convictions of it, they hit me with another possession.
So what are you doing to help maintain your sobriety? Are you going to meetings? Do you have a
Meetings.
sponsor?
Going to meetings, and then my it's I won't say it's an actual sponsor, but it's my little brother Ricky. He helps. I talk to him every day.
And
Like,
he's sober?
yes, he's never used. But he smoked pot once or twice. He lives in Minnesota, but we video
Okay.
chat a couple times a day.
What meetings do you go to?
The Alamo Club in St. Clair Falls,
And when are those meetings?
usually on Fridays.
Do you know what time?
Yeah, five or 6.
Okay. And you try to go to those meetings when you can?
Yes,
And so if I have you tested right now for methamphetamine or any other drug, would you test positive?
I'm not sure.
What do you mean you're not sure?
My old lady does it.
Your old lady does it?
Yeah, my girlfriend, which she's got has a subpoena for court case for you guys.
Oh, well, then don't tell me who she is. Please don't refer to your girlfriend as your old lady.
But she's 40 years old.
Does not mean she's an old lady. And Yes. Significant other, 40, 50, whatever. If she's your significant other, she's not an old lady. That's very derogatory.
Well, I didn't mean it like that, but
I know. Let's try and change your way of thinking as it relates to that, as you're trying to change your way of thinking with regards to substance abuse and your sobriety. Okay.
all right.
So what is your significant other doing to try and maintain her sobriety?
Stay out of trouble, I believe.
Is she
I'm not
going
sure.
to meetings as well?
She does when she can.
Okay. Well, Mr. Frank, this goes back way to 2017. I've had you in custody for a week. I did Lieutenant here. Would you say, Lieutenant, that it would be about 8 days of jail credit? And you can guess.
I would say that sounds about right. I can't recall off the top of my head what day he was brought into custody.
Okay, but the 8th or the 9th sounds about familiar.
Yes.
Okay, thank you. All right, Mr. Frank, here's what I'm going to do. Because you have not had any other criminal convictions within my county. So thank you. I appreciate that. So since 2017, I don't want to see you getting into any other trouble or get any other crimes or charges against you or convictions. But in my county, I'm going to tell you, you've been good since 2017. I recall your history. I am my condolences for the loss of your father. I know he was a big support to you, and that's where you resided for a lengthy period of time. What I'm going to do, Mr. Frank, is I am going to waive all of the fees in lieu of 8 days of jail. Well, actually, let's say 10 days of jail, because I think you can get good time with that. So let me just verify. Yeah, so I'm going to sentence you to 10 days of jail. You have 8 days of jail credit. That's what we'll say, 8 days of jail credit, and it's a time served. And so you can be released. And so I'm going to waive all of the fees except for that $200 DNA surcharge, which I cannot waive, and the $15 that I'm seeing in payment plan fees, which go to the county to monitor these things and to do these things. So those are the amounts you're going to have to pay, $215, okay?
All right.
And so what I'm going to do is you're going to be released today. You've promised me you're going to go sign up for your insurance again. You've promised me that you're going to go back to your doctor and look at your medications and what could be a better fit and how you can take them as prescribed to help you with your mental health. And then I'm going to stay any repayment of that $215. I'm going to give you 3 months. Okay. So I'm just going to say first payment of $25 at least starting in January. I'm hoping that you're going to promise me that once you sell the home and if you get a share of those funds, that you will just come and pay all of that off at once with Burnett County. Would you do that?
How much is the fine?
$215. I'm waiving $450 or something.
All right. Thank you.
Okay. So, but if you don't, a warrant will be issued again. You will be sitting again, and that would be a contempt, and it could be a jail sentence without getting any other waivers of fines and fees because I'm mandated to have these. Do you understand?
Yes.
All right. And so you understand that you do need to pay this $215 back?
Yes.
All right. And first payment again in January, unless you sell the house, and you can come pay it all off in full. Okay.
All right. Thank you.
All right. Thank you. Then we are adjourned.
All right. Thank you.